Welcome to War Story Wednesdays. Today I want to talk about water problems. Condominium water problems. One court of appeals has said that litigation related to condominiums is as common as crabgrass in California. It's just everywhere. And I think they're probably right. And one of the things that we always see with respect to condominium and construction defect litigation is water intrusion, water problems. All those fancy little angles and roof lines, every seam in a building is just a place for water to come filtering in. This condominium, no exception. In fact, over a 3-year period, not less than 31 different items had come up within the homeowners association related to water problems. And finally, it got to a point where the condominium association needed to sue the general contractor. Well, like most things, it's all about timing, right? The seller of one of those units had a deal and signed off on the deal, and the buyer was doing inspections and decided it's just not right and canceled. And after that cancellation, the homeowners association had a vote, sent out a notice, they're going to sue the contractor. The buyer came back after that notice had been delivered to everybody and made another offer, $5,000 less than the original offer. In the seller disclosure documents, the buyer was advised that the condominium association was in the middle of a lawsuit with respect to water problems. Now, the seller had a friend who was another owner, 3 of them actually, who had suffered severe water problems in their units and knew of the litigation and had received the 31 letters. But in her particular unit, there hadn't been any water problems. Well, not really, anyway. There had been that white efflorescence, that chalky stuff on one of the garage walls, and on the outside of the garage there was moss or algae that had grown. So, that indicated that there was water, but not a water problem. So you can guess what happened. Shortly after the buyer buys the property, guess what they learn? That this condominium unit also has severe water problems. The buyer is unhappy with both having to chip in through common area dues for the litigation, as well as now having to fix the water problems inside their unit. So the buyer sues the broker and the seller for non-disclosure. As to the broker, the claim is that the broker should have disclosed the efflorescence and the algae and moss on the outside of the garage, and failing to do so was a breach of the duty of disclosure. The seller, the buyer said, should similarly have disclosed those items. And the Court of Appeal said no, that it's important, and in fact a legal duty, to disclose facts about material defects in a property. But efflorescence and moss on the outside of a building over a year prior to the sale wasn't, according to the Court of Appeal, a material fact necessitating disclosure. And so both the seller and the broker escaped liability. While the Court of Appeal determined that these items didn't constitute material red flags that would have given rise to a duty to disclose or would have triggered further investigation by the buyer, is a really close call. The seller and the broker here escaped potential liability, where on even a slightly different set of facts, in my opinion, the broker would have found themselves liable to the buyer client. I would not take great comfort in this case if I were a real estate broker. I would have disclosed the efflorescence and the moss. It's indicative of water standing around long enough along the side of a building to cause staining. or moss or algae growth. That is more than a typical amount of water from rain runoff. That could lead to evidence of other water problems. I would disclose it. I would urge you to disclose it. Because if you do, you have less likely a need to call me to defend you.